Asia. A year after the Supreme Court of India ended age-based discrimination on entry of women into the Sabarimala shrine in Kerala, a five-judge bench will give its verdict on a set of review petitions that want this decision reversed. The decision involves a classic case where faith and belief clash with gender equality. Women aged 10 and 50 years had no right to enter the century-old shrine till the court decided to step in. On September the 28th last year, the Supreme Court of India created history by opening the gates of the Sabarimala shrine to women of all ages. This sparked a series of protests as the administrators of the temple refused to permit the court decision to be implemented, claiming that the century-old practice is a matter of faith. Several persons and groups approached the court for a review of the judgment and protection of their religious belief. The court agreed to hear the review petitions in open court, which reserved its decision after an extensive second round of arguments. The five-judge bench is headed by Chief Justice of India Ranjan Gogoi and has Justices R.F. Nariman, A.M. Khanvilkar, D.Y. Chandrachud and Indu Malhotra as its other members. The deity at Sabarimala is Lord Ayyappa, who is believed to be in a state of permanent celibacy. This is cited as the reason behind the age-old practice denying women of menstrual age group to enter the temple. The judges who set aside the ban on women scoffed at the discriminatory religious custom being founded on a purely biological process such as menstruation. The lone judge on the bench to differ with the majority view was a woman. She felt that a religious practice must be concluded based on evidence in a trial court and cannot be decided in a public interest litigation petition. Now, there are in all 56 review petitions, 4 writ petitions and 5 transfer pleas that the court will decide on. Security arrangements have been tightened in Kerala ahead of the verdict. It's a big day ahead in the Supreme Court of India that will determine the fate of the multi-million-dollar Rafale warplane deal signed between India and France. The deal initially got a clean sheet from the Indian top court, but a review petition filed later by a lawyer and 2 former politicians accused the government of suppressing information. The court found this charge serious and decided to hear the matter all over again. It was in 2016 India signed a US $8.7 million deal with French firm Dassault for purchase of 36 Rafale fighter jets. The deal came under a cloud after final details of the deal revealed that it was priced very high. Dassault later disclosed that it had made Reliance Defence as its offset Indian partner. This company had no past experience in the area of defence equipment manufacturing. Now, these facts were brought for the Supreme Court's attention in a public interest litigation petition filed by leading political and social activists in the country. A bench of Chief Justice of India Ranjan Gogoi, Justices S.K. Kaul and K.M. Joseph in December last year found no irregularity in the government's handling of the deal so far as price was concerned. The court kept the details confidential. As regards Reliance Defence, the government said it was up to the French firm which to choose as its offset partner. The litigants who filed the PIL spotted factual errors in the judgment and filed a review petition for rectification. This hearing was held by the 3-judge bench that gave the earlier decision. The court reserved verdict on the review pleas in May this year. Along with the main case, the court will be deciding on a contempt petition against Congress leader Rahul Gandhi. A plea was moved by BJP parliamentarian Meenakshi Lekhi, who took affront to Rahul Gandhi misleading public over the court decision on Rafale deal. The Congress party and its leader later apologized for his comments.